Judge Lucas on our lawsuit against Union Township to enforce the mediation settlement. I'd like to just go over that decision with you very briefly so that everybody understands it. And if you have any, part of the decision requires us to submit a confidential mediation statement, and I would like to discuss some of the terms of that confidential mediation statement that I recommend in executive session with regard to any offers that you're going to authorize me to make or us to make. And I'd also like to discuss an appointment of a committee to attend the mediation with me. But if you take a look, I think everyone has the memorandum in order, and I'll just give you the highlights of it. Judge Lucas found that Mr. Vreeland, the court-ordered facilitator, as he refers to him in the decision, that plainly stated the parties had an agreement to pursue a plan that included a lift station as opposed to one involving grinder pumps in his memorandum. He found that all parties were aware that this lift station would be more expensive than the estimates that the engineers had originally proposed a few years prior. He found that the parties agreed to have their engineers share information and move quickly. He found that Union Township had agreed to pay 100% of the cost of the project with the lift station option. He found that PCSA agreed that it would provide engineering and the overall construction. He found that the boards all agreed that they would meet and present this agreement to their respective boards for ratification. But he, in his decision, and I quote him, he said he noted that Union Township did otherwise and called for a resolution that included grinder pumps. However, the agreement is a little confusing to read, so I've read it a couple times, so I'd just like to clarify it for you. What he found was, as I think I predicted, that the agreement was not enforceable for a couple of reasons. Number one, during the dictation of the agreement, it was understood that it would be subject to each of our respective boards voting on it and ratifying it. And number two, he has a discussion in there that our board did not give me authority to bind the board, and Union Township board did not give their respective attorneys to bind their board. So he found for that reason, even though we had this tentative agreement on the record and we all agreed to proceed in good faith, he found that he could not order that we had an enforceable agreement. And because he could not order that there was an enforceable agreement, he did not award us reimbursement for attorney fees, because he found that if there was no, since there was no enforceable agreement, I can't order attorney fees. But then he goes on to criticize Union Township for being anything but prompt in his decision, and he also, in his decision, very specifically says that sanctions are warranted against Union Township. He said that the reason he awarded sanctions was because in his previous order he had ordered all members of both sides to be available by telephone, and he noted that Michelle Dupree had testified that she never knew about the tentative agreement until the date of the March 23rd meeting, and even then she was not informed that there was a preliminary agreement concerning lift stations, but instead she was asked to vote on a grinder pump option, so she had no idea what was discussed in court. And he said that violated his order that everyone should be available by telephone, and that the agreement should have been presented to everybody for a vote. And then he also noted that when Union Township voted on the agreement, they voted on an entirely different agreement than was presented in court. And he found that to be in violation of good faith, in violation of his orders. And so he ordered sanctions. The sanctions he ordered were significant. He ordered, and they don't apply to us, he ordered all of the Union Township supervisors to attend the 4 scheduled mediation sessions. We have 4 sessions scheduled. One's on a Friday, the next 3 are on Monday, Tuesday, and Wednesday. I forget the dates, quite frankly. They're in the order that follows. September 23rd, 28th, 29th, and 30th. So that's a major inconvenience for those supervisors. They all have to attend. he also ordered that they have to pay all of Mr. Breland's fees. Mr. Breland's fees are typically, $300 to $400 per hour. And if we go through 4 sessions with Mr. Breland, there's gonna be a lot of fees that he's gonna charge, and we don't have to pay for those. So, I know we didn't get reimbursed for attorney fees, but I think it's very seldom that a judge will find a municipal entity get sanctions, and I think in this case, the court were those. I would ask if you have any questions about strategy for the mediation or the proposals that we discussed at an executive session, because I don't think it's fair to have those discussions in front of the Union Township folks. If you have any questions about the decision and what it says and what it means, I'll be happy to answer those before I move on to the next topic.
Is there a possibility